Thanks for watching this episode 37, 38 and 39 in regards to the judgment. So watch to the end of this episode and you'll get lots of good tips in regards to what to do for yourself in regards to, litigating or, just gathering information or evidence to help support your case, whether you can afford a lawyer or not. So yeah, and don't forget to subscribe and press like, and I'll see you at the end of this clip. Welcome back to my channel. So I will just continue on with what's on the actual judgment, and I will be reading majority of what was quoted. I'm quoting it from the actual judgment, so I will be reading and referring to my notes. So I'll get straight on to it. Okay, the fourth defendant, point 40. The fourth defendant, he's the one that did the medical assessment for the employer, assessed the plaintiff's health and safety and competency to be at work at the request of the then manager of the district court. The plaintiff claims that the report prepared was pivotal to in the termination of employment. In regards to the investigation by the employer, on the 10th of July 2015, I'd actually lodged an official complaints in regards to the cyber attacks and bullying that I was subject to within the workplace. So on this day, I officially lodged complaints to the union rep and to the service manager. Then on the 22nd of July 2015, two staff laid complaints against me. But by this time I was actually taken off site from work because of the complaints and what I was going through at work. But when before I laid my complaints, the hostility within the workplace was very hostile. Health and safety issue, it was dangerous. You'd think I'd get used to it, but I'd gotten to the point leading up to that, the frustration and just the upset that it just wouldn't stop. And I just couldn't do anything about it. So, I have reacted. There were times where I got, upset about it, and I showed my frustration. When things, happen, because, it just wouldn't stop. But it got so bad that I decided that at a stand-up meeting, we had this stand-up meeting, a team meeting. Everyone knows I'm, very open, and that at this stand-up team meeting, everyone is, in the team would address different issues, throughout the week or throughout the day, and then we look at solutions as, how we're going to resolve it as a team. Because at that time, the workplace environment or the team that I was under, which was criminal jurisdiction, it was where the registrars had to learn, bit of everything, because you get used for everything. You didn't have a set job that was yours. Whoever did the scheduling of what court you did for the week or the next few weeks or you know, they had a separate person who did the scheduling. So we never really know in advance what our day holds, because we could be put in one court, we could be scheduled for one court one day, and then you go into the office and then you're being asked to go and cover another court, maybe because short staff or something like that. So that's how the actual at that time it was called the court activity team. And so we all got moved around. The most experienced staff, were able to, you're relied on to just pick up the pieces, or, like you basically pick up somebody else's job and while they're away. So they sort of broke down the roles. So you could be taking court one day as a court registrar, and then you're in the office doing the hub desk, which is updating, and or sometimes case managing. But each job it's very technical and very detailed and takes a lot of concentration. I'm just kind of explaining the environment. So we had, as a team, a stand-up meeting where all the team gets together, and then we address issues or, anything to do as a team, we sort of sort out and stuff like that. And then we just get on with our day. But because at this time, I was frustrated with the actual environment I was under, the criminal harassment, the abuse, indirect abuse, psychological, mental abuse. And yeah, it was just very dangerous and very hostile. So at the stand-up meeting, I think there were maybe, just thinking on top of my head, there was roughly about 8 to 10 staff at this meeting, maybe a little bit, maybe more. I know few were away. And at this meeting, I had made an announcement that I wanted the bullying to stop. I wanted, I'd had enough because I just couldn't understand why it was happening. But it was something that was going on for a long, long time, on and off, where I felt I was left out, or I felt I was being exiled or isolated or singled out. But I got the what I was going through at work was making me feel unsafe. So at the stand-up meeting, I made an announcement to the whole team that if it didn't stop, I was going to take it to the next level. But by this time, whoever was behind what I was going through had actually, had gone too far. So that's when that was brought up. And then, when you're going through so much hostility and just the bullying, it was terrible. And, just like anyone, the odd time I've reacted. Usually I'm very tolerant, patient. You won't know my emotions unless I let you know. Yeah, I was frustrated, and I'd gone to the point where I was feeling unsafe, and I refused to work in that condition anymore. So I made that announcement at the last team meeting. Before that was the last one I ever had. Then I never saw anybody ever again after that. And with that, I made official complaints to the union rep and to the actual service manager at this time. Point 41, the plaintiff included in her affidavit her termination letter of 1st of December 2015. As part of the exhibits, I submitted the actual termination letter that was written by my employer at the time. who made the decision, the final decision for this. The letter indicates the following paragraph. The available evidence satisfies me that A. Minna is not medically fit to properly perform the duties and responsibilities of her position by reason of a mental illness or other mental health issue she is suffering. Minna will not be medically fit to properly perform the duties and responsibilities of her position by reason of a mental illness or other mental health issue she is suffering. Minna will not be medically fit to properly perform the duties and responsibilities of her position within a reasonable foreseeable period. This is particularly in circumstances where Minna continues to reject in the strongest possible terms that these are only problem whatsoever. In regards to the letter that the service manager actually wrote, I've typed it out I've left out names and stuff, but I've actually typed out the points that were relevant. So if you watch the other episodes, the employer that with the signature on this actual letter, his decision was based on the actual investigation report that was made by the actual another staff who did the investigation on the actual evidence that was given to him or collated at the time of the investigation. So the decision that this letter goes by the actual report, whereas this employer who wrote this letter, he's only new in the picture at the time he made this decision. So he didn't know my background. He didn't know about my historical issues that I had within the workplace with the manager that was still a manager at the time. He was new on board at the time all this took place, and I did try to tell him, but he didn't know the history of my employment, whereas the general manager that was actually on the recording in one of the episodes, he was well aware of everything since 2010. Not too sure about the exact date, but roughly on or about September, October 2013. I had a meeting with the service manager, the manager that was my manager in my section at that time, a clinical psychologist that I was referred to by my family GP. Now at this period of time, we're rewinding back to 2013. So at this meeting, the psychologist came with me as a support person. Also at this meeting was the senior HR, who is the same senior HR who was there when I had a meeting in regards to the protected disclosure application with management in 2010. I brought up about the protected disclosure at this meeting. Now I wasn't sure what was the purpose of this meeting in advance. But at this period of time, I had refused to do the counter. because I knew I was being micromanaged. The reason why I refused to do the counter was because of the criminal harassment that was happening, that, you know, when I left work, going home and coming back, and in between, you know, the criminal harassment, it was a hostile situation for me. And so that's the reason why I had refused to do the counter. So if you've been watching me on Facebook around about 2016, and I actually put that CD up, and I went through a list of people with this oral recording. That's a CD, the one I was talking about, on the 4th of February 2016. I had mentioned names of different individuals at this stage, and at this period of time, I had reason to believe that my friend was missing. To be honest, at that stage, I was even though I didn't show it on the outside, I was actually living in fear. I was in fear for my safety, because I knew that what I was going through was serious, and I was scared because I didn't know what to do about it. Everyone was treating me invisible, yet in, you know, what I was going through at the time, not only I was putting up with the abuse, whether it be at work, in the public, or wherever I went, you know, in my mind I knew I wasn't safe just to go anywhere, because of the stalking that was continuous, and I didn't know what to do about it. So I took my own protection, and I decided I actually refused to do the counter for those reasons, because I was starting to fear for my life at this time. My friend stopped visiting me, and so I went and actually filed a police report that she was missing. That report's not there today, but I did. So I had to do what I could do to protect myself. But I had, you know, the situation I was in, I didn't get to choose what I did for the day, and I didn't know what to do about it. So I took my own protection, and I decided I actually refused to do the counter for those reasons, because I was starting to fear for my life at this time. My friend stopped visiting me, and so I went and actually filed a police report that she was missing. That report's not there today, but I did. So I had to do what I could do to protect myself. But I had, you know, the situation I was in, I didn't get to choose what I did for the day. Whereas I've been a registrar in other sections, or, you know, we had set jobs and we were responsible for our set jobs, and that's the kind of work environment I enjoyed. But I refused to do the counter for those very reasons, because I was protecting myself. I was taking, you know, I was putting my foot down and refusing to do the counter. To them, it looked like I was being defiant and refusing to obey. But this is after me telling them and being a broken record and telling them about the criminal harassment, but everyone just ignored me. So that's the reason why my family GP, the same one that referred me to this hearing, or to the oral assessment with the defendant, with defendant one, yes, the same family GP, she referred me to the clinical psychologist at this time. And so they had this meeting because they wanted me to do the counter, and I refused to do the counter. So she came as a support. I told her everything that I was going through at work. In fact, all the medical evidence that I had actually submitted as exhibits, every single medical certificate refers to workplace discrimination. And this is where this whole incident first came up again, where I had a meeting with this employer, the senior HR, who was aware of the protected disclosure in 2010 and everything else that I've already mentioned. So this employer or service manager, who was my service manager at the time, he was new on board, so he didn't know the history of what I'd gone through, whereas other staff did. But in saying that, he made the decision on the actual report of the investigation that was made, which is not very good or safe for those that are new on board, because they don't know the history, so they're like walking blind into the situation. And saying that the people that represented me at the time actually let me down. But in saying that, this was resolved at a employment process. But I'll carry on. Now, point 42. The light of the above passage in her termination letter, the plaintiff has good reasons for submitting the fourth defendant's letter, was a critical factor in the decision to terminate her employment. The person that was responsible for the actual investigation on the report, who actually wrote this report for this manager to make a final decision on me, he would have had all that information, the information that he collated from the investigation report, and the doctor that wrote the report, he would have gathered all that together. And yeah, if you had read it, you're like, I saw the report myself, and it just didn't look good. I just knew that they were going to terminate me right from in the heat of what I was going through, before I was even pushed out eventually, that it was going to get really, really worse for me, and it did. But what I'm trying to say is that the actual evidence didn't look good in my favor at all, but they were all one-sided evidence. My evidence wasn't investigated properly. They didn't even consider any of the evidence that I had asked them to look into, even though I was the one who first made the complaints about what I was subject to in the office. Two of them were definitely on the protected disclosure, because I actually had names of individuals whom I suspected that were involved in the alliance of undermining, because that's what I was going through. I was getting undermined and just outnumbered. Yeah, it was a very, very health and safety dangerous set of circumstance at the time. Point 43. After her employment was terminated, the plaintiff made a claim in the employment court for an unfair and unjust dismissal. She states these proceedings were successful. Point 45. There is no suggestion whatsoever in the fourth defendant's report that he made with the plaintiff before completing his assessment. It's very clear from reading his assessment that he did not. The information he was requested to take into account was the information provided to him by the employer, not the fourth defendant. In light of the plaintiff's successful action in the employment court for wrongful termination of her employment, I can detect no possible cause of action the plaintiff might have against the fourth defendant. The role in her employment termination was indirect, pause there. Note, judges just said it was indirect, which is, even though it's just one word, it indicates that everything that I've gone through has been indirect and one-sided. The decision to terminate the plaintiff's employment was not made by the fourth defendant, and his report carefully records the limited information he had regards to when preparing his report. Defendant is a party to an offence clearly indicated that the fourth defendant had operated outside his scope as a medical practitioner. He also committed other offences according to the criminal legislation. Now that's my own words. I've just written in that little paragraph. That's what actually came out as the hearing continued in the courts. First, second and third defendant. Point 47. The three remaining defendants appear in some way to have been involved in or linked to the decisions made on the 4th February 2016 under section 10 and 11, under the section 10 and 11 of the Mental Health Act, that there were reasonable further assessment and treatment could not be provided in an outpatient facility. These decisions resulted in her detention initially for 5-day period. So they took my liberty away, locked me up for 5 days. Point 48. The plaintiff complaint against 3 individuals is that they had a role in her detention, which she claims was unlawful. If the grounds relied upon for the decision made at the time on the plaintiff's detention were deficient, the plaintiff may have a possible claim against these defendants in tort for false imprisonment. Point 51. I am completely satisfied that even on the most favourable interpretation of the statement of claim or additional materials the plaintiff has filed, the plaintiff does not have a cause of action against the fourth defendant. The plaintiff's claim against these defendants is so clearly untangible it cannot possibly succeed, even if she was given an opportunity to formulate her claim. I therefore strike out these portions of the statement that relate to the 4th, 5th and 6th defendants. So from this judgment onwards, the case was now no longer against 6 defendants, but 3 defendants, being defendant 4, 5 and 6. The reason for this is because the judge did struck out my claim in regards to these 3 defendants, and from what she's written in her judgment, she's not satisfied that I've proven a cause of action. Point 52. The plaintiff's claim against the remaining 3 defendants, 1, 2 and 3 defendant, is markedly different to the others. I hesitate to state that the plaintiff's detention was a direct result of the assessments and the decision of these defendants. While these defendants may have been a party to decisions made, counsel was unable to specify the event of their involvement, and the plaintiff's materials do not assist in identifying the persons responsible for the decision to detain her. More information is required. However, if these defendants were either individually or collectively the relevant decision makers, a possible claim in tort could be brought. The present claim is deficient, but an amendment claim may be tangible. It is not yet beyond repair and could be reformulated into an actionable claim. I am therefore not satisfied the grounds to strike out the plaintiff's claim against the first, second and third defendants are made out. The portions of the statement of claim relating to these three defendants will remain. So judge didn't, she's just confirmed here that she's not striking out my claim against the three defendants, which is defendant number 1, 2 and 3. So these are the defendants that I had that enforced the Mental Health Act. So at this stage of the case, and the usual processes are, liability, strict order of liability should have been done. But judge didn't strike out these three defendants, and she felt that I had a case. She was satisfied that I actually had a case that was sufficient against these three defendants. Point 53. In light of my decision to strike out a portion of the plaintiff's claim, a revised and more tightly focused statement of claim is required. This claim needs to be clearly specified the role the three remaining defendants 1, 2 and 3 had in the decision to detain the plaintiff on the 4th of February 2016 and the grounds upon which it is alleged that the decision failed to meet the statutory criteria. If one of these defendants was not a party to the decision to detain the plaintiff, will not be carefully considered what possible claim she could have against that particular defendant. The lack of sufficient detail specifying their particular roles and how their respective decisions were deficient will result in further scrutiny of these proceedings. I'll just pause there. It was actually clearly noted of their roles in the case in the statement of claim. Point 55. The plaintiff is to file an amendment statement of claim with 28 days being Wednesday the 7th of June 2017. The defendants are to file an amendment statement of defence 28 days thereafter. So I'll pause here. The judge has made a request for me to change the names of the defendants because it was under, she claimed that was under a different entity, which is, she's quite right there. But if my file wasn't being sabotaged, I basically covered everything according to the law. If everything was on file and the judge got everything that, to prove that I had the names correct. The names were also, it was actually advised to me by the DR who case managed my case at this time. So she's also asked for the councils to put in a statement of defence, because they hadn't, at this stage, they hadn't put in a statement of defence of any sort, and they hadn't right to the end of the actual court process this case was going through. So we've come to the end of this episode, and for those who don't who has never been in a platform of a court, one thing that seem or sound like, you know, the individual is being repetitive, because that is how it is in the platform of a court, and usually it takes months, weeks and months for, you know, to actually case manage our case for one individual. And that's why these video clips have taken quite a bit of time. I know sometimes it's taken me like 3 weeks just to even just do one, focusing on one topic. But what I've wanted to bring out there is just the key factors, or the key elements of the actual case. Yeah, I mean, there's a lot more detail that actually goes in with, you know, one case, and as far as the law is concerned, but I'm just picking out the basics and focusing on that, and then just you know, explaining it in the language where everyone can understand what I'm talking about. So if you've ever been in the platform of a court, usually, you know, most of the people, even councils, or, you know, or who work in that environment, do sound like they are being repetitive when it comes to talking about certain things, and basically you are being repetitive because you have to actually focus on the key points of whatever you're, you know, trying to explain or bring forth. That's really important. I will finish it there. Hope you've enjoyed this clip, and thank you for watching.